ここからは裁判所パートです。それではパネルディスカッションを開始いたします。テーマは激動する時代とこれからの知財司法です。それではパネリストの皆様をご紹介いたします。中平健知的財産高等裁判所武装括裁判官、菊池恵里知的財産高等裁判所裁判官、ハン・ギュヒョン韓国知的財産高等法院院長、クラウス・グラビンスキー欧州統一特許裁判所控訴裁判所長官、レイモンド・チェン米国連邦巡回区控訴裁判所裁判官、藤川義人日本弁護士連合会知的財産センター委員長、モデレーターは知的財産高等裁判所天野健二裁判官、城山康文アンダーソン毛利友常法律事務所外国法共同事業弁護士、以上の皆様でパネルディスカッションを行います。それではここからの進行をモデレーターのお二人にお願いしたいと存じます。天野裁判官、そして城山弁護士、よろしくお願いいたします。
ではですね、これからの時間は、激動する時代とこれからの知財司法と題したパネルディスカッションを行います。知財高裁は今年で20周年という節目を迎えました。今後変化の激しい社会で、私たち裁判所は、どのように進化していくべきなのか、海外の特許専門裁判所の実務を参照しながら考えていきたいと思います。本題に入る前にですね、海外からおいでいただいたゲスト裁判官のお人柄を、知るという意味でアイスブレイク的な質問をいたしたいと思います。こちらです。はい。この20年間、個人的または職業的生活において、最もメモリアルだった出来事は何でしょうかと。お人柄を知りたいので、できればパーソナル、差し支えなければパーソナルで、もちろんプロフェッショナルでも OK なんですけれども、教えていただければと思います。私の場合はこちらに映っております猫のココちゃんを家族の一員として迎えたっていうのがメモリアルな出来事の一つということになってますので、ぜひ皆様のエピソードを聞かせていただければと思います。でははじめにですね、韓国のハイン長にお願いしたいんですけど、안녕하세요。일본에와주셔서감사합니다。よろしくお願いします。
곤니치와. 어제 만나 뵙고 또 오늘 또 만나 뵙게 되어서 정말 더욱 반갑습니다. 질문에 답변 드리도록 하겠습니다. 그동안 제 삶에서 가장 기억나는 순간은 2001년 취미로 IP 법률 공부를 시작한 시점입니다. 그때는 저는 임관 8년차 법관이었습니다. 대법원에서 마련해준 전문 연수 프로그램으로 대학원에서 IP 법률 공부를 하게 되었습니다. 이 선택은 지난 25년 동안 저에게 엄청난 변화를 주었습니다. 그동안 저는 대학원에서 IP 법률을 전공했고 대법원에서 IP 사건을 다루는 재판 연구관을 하고 서울중앙지방법원, 특허법원, 서울고등법원 등에서 합의부 재판장으로서 IP 사건을 재판했습니다. 이제는 대한민국 법원을 대표하는 IP 전문법관이 되었습니다. 특히 2015년에는 대한민국 특허법원 수석 부장판사로서 대한민국 IP 코트의 전문성과 국제적 경쟁력을 강화하는 IP 허브 코트도 추진했습니다. 2025년 2월부터는 대한민국 특허법원장으로서 IP 소송 절차 개선 작업을 해가면서 많은 보람을 느끼고 있습니다. 게다가 일본 지적재산고등재판소 설립 20주년을 기념하는 이렇게 뜻깊은 심포지엄에까지 오게 되었으니 저의 기쁨은 더 말할 나위가 없습니다. 감사합니다.
ありがとうございました。それではグラビンスキー使用官ですけど、Guten Tag, lange nicht gesehen. Es freut mich, Sie wiedersehen. じゃあよろしくお願いします。
Good afternoon. Thank you very much. Seeing you again, it's a great pleasure to me. There's one event, of course, in my professional life, which is very important to me. This was the 1st June 2023, when the UPC was up and running. I was involved in the project more than 20 years before, in the capacity of member of different committees, first with the German Ministry of Justice, later was a member of a commission set up by the European Commission, and then I was also a member of the so-called drafting committee that drafted the rules of procedure that are now applicable in the UPC. So of course, when then after all this work, and there were a lot of ups and downs during the time, and there was also a time when at least many did not believe it will become true, but then it became true. So this was indeed a very important moment in my professional life, and one important moment in my private life was that this year, for the first time, I climbed a 6,000 meter mountain in Bolivia.
ありがとうございました。では、ジャッジチェン、Good afternoon. We are deeply honored to welcome you from the Federal Circuit. Also, I'd like to extend our sincere gratitude to Honorable Chief Judge Kimberly Moore of Federal Circuit, who is not here, but realized Judge Chen's arrival here in Japan. Thank you so much. So please give me your episode, please.
Okay, thank you. Konnichiwa. Now that I'm looking at Judge Amano's beautiful cat, I should probably say the most memorable moment in the past 20 years is the arrival of my dog, Hiro, H-I-R-O, who's a Shih Tzu. And I love that dog. But that wasn't what I was planning on talking about. In August 2012, I was on a Mediterranean cruise with my family. And I remember being in the cruise ship somewhere off the coast of Italy when I went back to my room to look at my BlackBerry, because I was, at the time, the head litigator for the USPTO. The title is solicitor. And I had to check my email. And I received an email from an attorney in the White House who sent me an email asking if I would be interested in talking to him about the open position at the Federal Circuit. And I remember being quite shocked by that email. I was so shocked I had to sit down on the bed and read the email over and over again to understand what it was trying to say to me. And so that is something that was a major moment for me. And then after some rounds of interviews, I was eventually nominated by President Obama.
はい、ありがとうございました。それでは本題に入っていきたいと思います。今日はですね、私たち、 知財に限らないことですが、裁判所が現在直面している課題、チャレンジを考えるために、2つの問いを設定したということです。1つは、まず高度化する専門性にいかに対応していくかという点です。技術の進歩がさらに加速していく中、裁判所は、適正な判断の前提として、係争の対象となっている技術を正確に理解するためにどうすればよいのでしょうか。それから2点目として、判断の社会的インパクトをいかに適切なものにするかという点です。技術が相互に関連し合う中で、裁判所の判断が当事者のみならず広く他の事業者等に与える影響も、無視できなくなっています。より広い視野に立った判断をしていくためにはどうしていけばよいのかと、このような2つの問いを考えるという形で今日のプログラムを進めていきたいと思います。それでは最初のキーチャレンジですけど、高度化する専門性にいかに対応していくかという点です。この点についてですね、まず、弁護士知財ネットの方に調査をお願いしました。で、昨日各裁判官から、各裁判所の実情をお話しいただいたわけですが、その復習の意味も込めて、ですね、城山弁護士に紹介していただきたいと思います。よろしくお願いします。
まず専門性獲得という方向ではですね、一つ専門裁判所の設置ということがございます。日弁連知財センターの小池真一委員が調査をしましたので、それを報告させていただきます。で、日本についてはこれはもう皆さんご承知の通りでありまして、東京侵害事件の一審は東日本は東京地裁、西日本は大阪地裁に専属管轄、控訴審については東京高等裁判所の特別支部としての知的財産高等裁判所が平成16年に設置されて本年で20周年ということであります。特許の有効性、無効性の問題というのは東京庁の審決で、最終的には決定されるわけですが、その審決の、違法性についてはやはり知財高裁の審決取消訴訟で行うことができる。また他方侵害訴訟においても、特許の有効性は抗弁として、権利の行使を妨げる事由として審理されることになります。でそうすると、侵害訴訟の控訴審と審決取消訴訟と、いずれも知的財産高等裁判所で、審理され、同時期にそれが継続しますと同一の合議体で審理をされて、統一性のある判断がなされるということが期待されております。続いて、韓国です。で、韓国についても昨日ご紹介いただきましたけれども、1998年に知的財産高等法院が設置されました。当初は審決取消訴訟の専属管轄だけだったようですが、2016年の法改正で侵害訴訟の控訴審についてもやはり専属管轄を有することとされています。それから一審段階でも地方法院、全国の地方法院のうち6つの地方法院だけが特許事件の管轄を有し、かつソウル中央地方法院というのはそれらと全部競合する管轄を有するということで、ソウル中央法院に集中する傾向があるというふうに伺っております。特許の有効性無効性についてはやはり日本と同様に侵害訴訟での判断と、東京庁の審決のルートでの判断と、両方あるということになるようです。続いて UPC です。欧州の UPC、今もお話ありましたけれども、2023年6月1日に運用が開始されたものと理解しています。いわゆるユニタリーパテント、欧州単一特許と、それからオプトアウトされてない EP ですね、欧州特許についての管轄、侵害訴訟の管轄と有効性の判断の管轄を有しています。で、一審については中央部が3カ所、地方部、地域部とで構成されて、控訴審はグラミンスキー中間のロクセンブルグに所在をしています。それからアメリカです。アメリカについてはやはりまず 特許法については、連邦法で定められているので、連邦地裁の管轄ということになります。でかつ、アメリカではやはり先例法主義ということがございますので、その判断を統一するという意味で、レーガン政権の下で CFC が設置をされたと理解しております。で特許の有効性の争い方としては、伝統的には侵害訴訟の抗弁として、特許無効が主張されるというものでありましたけれども、PGR あるいは IPR というですね、USPTO で特許の有効性を争うという手続きが最近多用されるようになってきたと聞いております。ただこれも逆に昨日チェンハン氏からも報告ありましたけれども、第二次トランプ政権の下ではこの IPR の申し立て、インターバルテレビューの申し立てを裁量で棄却するという割合が非常に高くなっているということを聞いておりまして、かつそれをルール化するという内規が今パブリックコメントに含まれているというようにも聞いております。アメリカはこのように政治によってかなり制度が動くというのが特徴かと思いますけれども、その辺について判事というのはどのように見られているかというのもぜひ聞いてみたいところかなと思っております。続いて、専門的知見の獲得という意味では、そのどのようなスタッフを所内に置くのか、あるいは外部の当事者から専門的知識を提供させるのか、ここも重要な判断になる、制度設計になるかと思います。で日本においてはこれもご承知の通りですけれども、調査官というものが常設の調査官が配置されています。東京地裁、大阪地裁の知財専門部、それから知財高裁には調査官がいらっしゃって、で多くの方は特許庁の審査官からの出向者の方々で、一部は弁理士の方から任期付きで採用されている方と思います。で調査官はその裁判官に対して合議体に対して議律内容等について調査官報告というレポートをされるものということを聞いておりますけれども、これはただいわゆる門外不出なんですね。当事者や代理人等に対しては開示をされないものであります。それから専門委員というのが任命されます。これは裁判所の方で専門委員の候補者のリストを持っていらっしゃって、事件ごとに専門委員が任命されます。で多くは技術説明会の際に専門委員が任命をされて質問等をされるということになっています。ただ当事者あるいは代理人から専門委員に対して逆に質問をするというようなことというのはできない制度となっております。で韓国はお聞きしたところですと日本と同様にやはり技術調査員あるいは技術審理官というものが常設の職員として配置されているようであります。で報告書の作成とか等をですねやはりされているようです。でこれについてはお聞きしたいなと思っているのが、そういう報告書、技術調査員の報告書のようなものは外部に開示されることはあるのかどうかというようなところは興味深いなと思っております。そして UPC です。UPC は何といっても昨日のご説明もありましたけれども、技術系裁判官を正面から制度の中に取り入れたというところであります。で昨日もありましたけれども実務家弁理士の先生とかあるいは各国あるいは EPO の審査官がですね兼職で採用されていることが多いようです。で技術系審査官に関してはお聞きしたいなと思うのはやはりこの技術系裁判官と法律系裁判官で合議体を組む時の合議の仕方だとかあるいは判決を書く際のロジックとか書き方とかというものについて 何かこれまでと違ってくるようなことがあるのかどうか、その辺の感覚を聞いているととても面白いなと思っております。それからアメリカです。アメリカは、常設のその専門委員のようあるいは調査官のような制度はないと、理解しておりますけれども、ただ、裁判官がですね、ロースクールの卒業生から採用するロークラークの中にはですね、やはり自然科学のバックグラウンドを持っていらっしゃる方が数多くいるというように聞いております。それから裁判所を補助する制度としてはテクニカルアドバイザーあるいはスペシャルマスターという制度があるというようにも聞いております。ただ、実際よく聞くのはですね、アメリカでは専門的知見の収集というのは何といっても当事者が申し出る専門家証人エキスパートウィットネスであって、エキスパートウィットネスの証言あるいはその反対尋問というものが専門的知見の収集の中心になるというように理解しております。でこれに関しては、アメリカではその、日本でいう調査官のようないわゆる中立的な立場からの技術的な情報というものを得たいなというようなことというのはないのかどうか、この辺が興味深いところであります。私からの報告は以上です。
白山弁護士ありがとうございました。じゃあここで答え合わせの時間ですね。日本から調査したものですから、実際に現場で、携わっておられる裁判官の皆様にちょっと確認合ってるかどうか確認したいと思うんですけれども、先ほどのプレゼンテーションについて、付け加えたり訂正または強調しておきたい点がございましたら教えてください。ハ院長からお願いします。
네, 시로야마 변호사님은 대한민국에서 특허 소송을 수행하시더라도 손색이 없을 정도로 대한민국 특허 소송 제도를 매우 잘 정리해서 말씀해 주셨습니다. 감사합니다. 그럼 질문에 대해서 답변을 드리도록 하겠습니다. 대한민국은 이제 기술심리관과 기술조사관 제도에 대해서 두 개의 제도가 있는데요. 부연해서 설명을 드리겠습니다. 시로야마 변호사님께서 조금 전에 말씀하신 바와 같이 대한민국 법원에서는 기술심리관과 기술조사관이 법관의 업무를 지원하고 있습니다. 현재 대법원에 6명, 서울중앙지방법원에 11명, 특허법원에 22명의 기술조사관과 기술심리관이 있습니다. 기술조사관과 기술심리관은 다양한 전문 기술 분야 출신인 점에서는 공통됩니다. 하지만 양자는 관여하는 재판에 차이가 있습니다. 기술조사관은 민사재판 및 형사재판에서 법관 업무를 지원합니다. 기술심리관은 특허법원 심결취소소송에서 법관 업무를 지원합니다. 기술심리관은 법정에서 재판장의 허가를 받아 소송관계인에게 기술적 사항에 관하여 질문할 수 있고 합의해서 의견을 진술할 수 있는 점에서 기술조사관과 차이가 있습니다. 다른 한편 기술심리관은 기술조사관으로도 지정되어 있어 민사재판 및 형사재판에서도 법관 업무를 지원하고 있습니다. 기술심리관과 기술조사관은 모두 법원에서 상근하고 있습니다. 대한민국 법원에서는 이들을 합하여 내부기술전문가라고 부르고 있습니다. 내부기술전문가는 자신에게 배당된 사건의 기술을 검토하여 보고서를 작성하고 이를 법관에게 제공하고 구두로 기술 설명을 합니다. 보고서에는 기술 용어에 대한 상세한 설명은 물론 기술적 쟁점에 대한 깊이 있는 연구 분석을 담고 있습니다. 법관은 내부 기술 전문가의 도움을 받아 변론기일 전에 기술을 충분히 이해하고 당사자가 제출한 서면 및 증거를 분석하여 기술적 쟁점을 정리한 다음 변론기일에서 쌍방의 기술 설명과 변론을 듣고 증거조사를 진행합니다. 한편 내부 전문가의 도움만으로 쉽게 해결되지 않는 고도의 전문 지식을 필요로 하는 사안에서는 해당 기술 분야에 깊은 식견을 갖고 있는 전문심리위원을 활용하고 있습니다. 전문심리위원은 법원에 상근하지 않는다는 의미에서 외부 기술 전문가라고 부릅니다. 전문심리위원은 이미 확보된 전문가 풀에서 지정되고 선서 의무가 없으며 재판장의 허가를 받아 변론기일에서 당사자, 증인, 감정인 등 소송관계인에게 직접 질문을 할 수 있습니다. 법원은 전문심리위원 제도를 활용하여 보다 신속하고 효율적으로 전문가의 설명이나 의견을 들을 수 있고 고도의 전문성을 갖는 기술에 관하여 이해도를 높일 수 있습니다. 전문심리위원은 민사소송뿐만 아니라 심결취소소송에서도 활용되고 있습니다. 또한 법원은 기술적 쟁점에 관하여 보다 깊은 이해를 하기 위해서 당사자의 신청에 의한 전문가를 민사소송법 제340조의 감정증인에 대한 신문 방식에 따라 증인으로 신문하기도 합니다. 전문가 증인은 특별한 학식과 경험에 의하여 알게 된 사실에 대하여 진술하는 증인입니다. 전문심리위원 제도와 달리 쌍방 당사자들은 전문가 증인에게 직접 주신문, 반대신문을 함으로써 주도적으로 사건을 이끌어갈 수 있다는 장점이 있습니다. 또한 비디오 등 중계장치에 의한 원격 영상 신문 방식으로 전문가 증인을 신문할 수 있습니다. 화상장치를 통해 혁신기술에 관한 해외 전문가 증언을 편리하게 청취할 수 있습니다. 다만 전문심리위원과 전문가 증언은 모든 사건에 대하여 활용되는 것은 아니고 내부 기술 전문가의 도움만으로 쉽게 해결되지 않거나 기술적 쟁점에 대한 보다 깊은 이해가 필요한 사안에 주로 활용됩니다. 이상으로 제 답변을 마치겠습니다. 감사합니다.
はい、ありがとうございました。それでは、グラビンスキー長官、同じ質問ですね。負荷、修正、強調したい点がございましたらお願いします。
Thank you. It was a very precise and consistent summary of the UPC system, so I have nothing to correct. Maybe I have a bit to add, explaining a bit more in detail the role of the technically qualified judges, because this concept, to my understanding, is not known in many other countries. So a technically qualified judge is not a technical expert, and it's also not an examiner. So what is the role of a technically qualified judge in the UPC? Let me explain this to you by telling you how it works in the proceedings before the UPC. So the first thing that happens is the so-called written procedure, which means that the parties submit statements. So it starts with a statement of claim, statement of defense, and then there's another round of statements from the parties. And the parties are supposed to submit to the court all the facts relevant for deciding the case, and all the arguments relevant for deciding the case, and all the requests they have for the courts. And it should all be already in the first statements, and then it's a kind of ping pong, and they reply to each other and then get a bit more into details. And it's a front-loading system which makes sure that a lot of the litigation or most of it is already submitted to the court in the written procedure, so that at the end the oral hearing should not take longer than on average a day. Once this written procedure has been closed, so usually after an exchange of two statements on both sides, there is an interim procedure, which essentially has for purpose to prepare the oral hearing. It also has for purpose to find out whether parties want to settle the case. But if settlement doesn't work, then it is essentially for preparing the oral hearing. And that can be that the judge rapporteur, who is in charge of running this interim procedure, may ask the parties to give further information with regard to certain aspects, or that the court needs a court-appointed expert, which up to now, as to my knowledge, never happened. Or the judge rapporteur summons a witness for the oral hearing. All these kinds of preparations are supposed to be done essentially in the interim procedure. And then there is an internal process once the interim procedure has come to a close, and also the day of the oral hearing has been set, where the judges prepare. And the technically qualified judge has already been assigned to the case for the latest at the end of the written procedure. So that means the technically qualified judge can assist judge rapporteur in the interim procedure already. But for the latest prior to the oral hearing, the judge rapporteur and also the technically qualified judge, or on appeal level there are two, so the technically qualified judges are supposed to draft internal opinions. Based on what has been submitted in the written procedure, essentially. So they have to read everything that has been submitted by the parties, and then write internal opinions. And the other judges, they are also supposed to read the files, and also, of course, read the opinions of their colleagues. And then a few days before the oral hearing, they all come together and have a first deliberation on the case. And by this, narrowing down, identifying the issues that most likely will be relevant. And at that stage, the role of the technically qualified judges, of course, also can be very important. So the judges try all the judges try to understand the technology of the case and what is relevant, and then there's a kind of complement each other. So the technically qualified judges have a deeper knowledge of the technology. The legally qualified judges may have a deeper knowledge of the law, but they complement each other. But this is all based on what has been submitted by the parties. So it is not that the judges have started a research on their own in order to prepare the case. That is not going to happen. And based on this pre-deliberation of the case, it depends a bit on the respective local flavor of the division, or also how the judges approach this. But I personally, at the beginning of the oral hearing, give a rather detailed introduction to the case to the parties. And by this, helping the parties to understand and make transparent where the court thinks the decisive issues are in the case. And then, only then, it is handed over to the parties to plead their cases. And the very good representatives, they understand that this is very important information for the parties. So then they essentially have to prepare everything. They may have a feeling what is will be relevant and what more relevant or less relevant, but essentially have to prepare everything, and then within the time limits that were communicated to the parties prior to the oral hearing, then respond. So if the case on the merit, it can be 1 or 2 hours that are given to each of the parties for for pleading, and then there's always a second round with less time to respond to each other. And during that time, the judges intervene. They ask questions to the parties, of course, including the technically qualified judges. From their perspective, there may be other questions that are relevant than from the legally qualified judges. The important thing of the questions, but also for the introductory remarks, is that all the points that later may become relevant for deciding the case, that the judges are aware of the position of the parties. So that is essentially what the right to be heard is about. So of course no party has a right that the case is decided in a specific way, but I think all the parties have the right to be heard, and that the judges take notice of what the arguments of the parties are with regard to the decisive points. Yes, and then a final deliberation takes place, and there all the judges are have the same position or have the same rights. They discuss the case. They may agree on at the end of the deliberation how the case should be decided. It may be that they do not agree, and if they do not agree, then they can issue also dissenting opinions, which up to now did not happen, but it would be possible. So that is essentially the way how it works, and the role of the technically qualified judges is, well, to that extent, they have a different background, but the role is the same like a legally qualified judge. Thank you.
はい、ありがとうございました。では前半時同じ質問させていただきますが、先ほどの説明に、修正、何付け加えることなど、強調しておきたい点がありましたらお願いします。
Yes, thank you. I understand the topic is about the importance of trying to understand very, very sophisticated and complicated technology in the judicial process. But I do want to spend a little bit of time right now answering the question from the moderator about the inter-parties reviews at the USPTO. That's not officially part of the topic, but I think it's such an important issue that the lawyers in Japan ought to understand what's going on at the USPTO right now with the new administration. And it's quite clear that this isn't, I don't want to suggest that I'm giving you my personal opinion as Judge Chen. I'm just trying to communicate as an observer what's going on at the USPTO and how they are making a concerted effort to cut down on the number of IPR proceedings that their patent board is going to be reviewing. And there are various reasons for why they're doing this. In the past 10 years, IPRs have become an incredibly significant feature of the patent system in the United States. The Federal Circuit over the past decade has been receiving more appeals from the patent board through the IPRs than the Federal Circuit has been receiving appeals from all the district courts in the United States. So over the past 10 years, generally, the Federal Circuit might receive about 400 appeals from the district courts and maybe 500 or 600 appeals from the patent board on IPRs. That's how significant of a change to the overall system IPRs have been in just a short period of time in the past decade. And I think now this new administration I don't think they want to have as many IPRs, and their philosophy is they would prefer if challengers come to the agency using PGRs, post-grant reviews. And post-grant reviews are very similar to the kinds of opposition proceedings that occur around the world where you have to come to the USPTO patent board within the first 9 months after a patent has been granted, and then challenge the patent. PGRs are different from IPRs in that PGRs you can rely on, you can attack a patent on any condition of patentability. So it's not just prior art challenges, which is what you're confined to do in an IPR. You can argue that a patent is ineligible under Section 101. You can argue that it lacks enablement, or the claims are too unclear and ambiguous, and so therefore it's invalid for that reason. But there's a policy choice that the USPTO has made, which is to have much fewer IPRs and try to encourage challengers to come to the USPTO through PGRs, and therefore identify problematic patents much earlier in the life of a patent. And the theory that we've been hearing from USPTO is that if a patent has been in existence for 6 years, 7 years, 8 years, then you've waited too long as a challenger. Even if your company didn't get sued until after year 7 or 8 in the course of a patent's life, coming to the PTO is too late and to use IPR. And so therefore you should just rely on your invalidity defenses in any kind of district court litigation. So that's the theory we've been hearing, and I would expect that you should be seeing that policy to remain for the next 3 years, at least over the course of this administration. Is that a good thing or is that a bad thing? I don't want to opine on that. I shouldn't opine on that. I have certain ethical restrictions on opining on such things. But I will say that when Congress enacted these IPRs and PGRs in 2011, nobody had anticipated at that time, nobody ever mentioned the idea that the PTO director might turn away meritorious petitions challenging the validity of patent claims on account of something like settled expectations, and therefore choosing to force challengers to come much earlier to the USPTO through PGRs. That said, there is another administrative pathway to challenge patents in the USPTO still, and that's called ex parte reexamination. Reexams have been around since 1980, and that type of proceeding's been forgotten in the past 10 years due to the popularity of IPRs. And IPRs have the great advantage of being completed within 1 year compared to an ex parte reexam, which is conducted in front of a patent examiner. And those proceedings take much longer because then you have to go work through the patent examiner, then eventually there's an appeal to the patent board before there might be an appeal to the federal circuit. So ex parte reexams, I suspect, will become more popular in the next few years. So I want the audience to understand that. Now, getting just very briefly to the question at hand about dealing with technology, it's very interesting for me to hear how courts in Japan and Korea and Europe deal with complicated technology and in patent litigation. We in the United States don't provide our courts with any kind of similar technical support. It's just not in the structure of the judiciary. And so the United States is in the minority, it appears. But maybe if the United States was working on a blank slate and was going to redesign how the courts handle patent litigation, maybe it would think about having internal technical advisors or technically qualified judges. But our patent litigation process is older, and I think there is just a culture and an attitude within the United States that our generalist judges can handle any kind of case. And they should handle any kind of case. But even the judges that see a lot of patent litigation, I'm talking about district court judges in Texas or Delaware or California, they understand that these cases are so extra complicated that what they do is often hire law clerks with technical backgrounds. And that's not because they want their law clerks to do additional outside research to collect information about the underlying technology. I think of it more as having a resource inside chambers that is able to help the judge understand what the lawyers are saying in the briefing and what the expert is saying in the expert report. You know, as a generalist judge, maybe it would be very hard to understand the science of antibodies or, you know, data packet switching and transmission of data over using internet protocols. I mean, that can be really hard to read through for the very first time. So it's very useful to have law clerks that are more comfortable with the technology that can more quickly explain it to the judge, or at least what the briefing is describing and what the expert reports are saying. I think one other theme about United States litigation is it's the parties that have the right to present their case. And so we rely on and allow the parties to explain their case the best way they can and the best way they feel. And what that often means in a patent litigation is a battle of the experts. I'm sure you've heard that expression before. And so what that means is each side gets its chance to present its case by, among other things, having its own expert. Now, the expert is supposed to be independent. It's not an employee of the party. It's usually a professor from some established, prestigious university that agrees with what that party is saying about the technology and how perhaps the defendant's product works and things like this. But then in terms of being able to really uncover the truth, that we rely heavily on the adversarial process of litigation. And that means each side gets to really scrutinize the other side's expert opinions and reports through depositions, and then if a case ever gets to trial, through cross-examination. And we do have a jury system in the United States, and as a general matter, patent trials are done with a jury as opposed to just a judge-only trial. You can have either, but most plaintiffs prefer to have a jury trial. And so we are putting a lot of pressure on juries, which are made up of ordinary US citizens, to try to understand what this technology really is and what was actually patented. But what I am told, I've never been a district court judge, but what I'm told by district court judges in the United States is that juries are able to figure out who is credible when they're on the witness stand and when they are being put to the test through cross-examination. And you can hear whose stories really hold together while they're testifying inside the witness box under oath. I guess I could keep going, but I'll just say the judges have an important, very important function when it comes to dealing with difficult technology. We're really counting on the judges to ask a lot of questions in technical tutorials that the parties provide. Sometimes at the Federal Circuit, I will see an appeal from a district court judge, and you can tell just by reading the transcript and the record which judges really are engaged with being stubbornly curious about trying to understand what the technology is, And occasionally you see judges that you can tell, oh no, this judge doesn't like patent cases. And this judge was not truly engaged with the case. And now we see some mistakes have been made. And so sometimes you see that. But as a general matter, what I've seen is judges really digging in and asking the hard questions and also regulating what kinds of evidence are actually permitted to go to trial and therefore making sure that junk science doesn't get to be presented in front of a jury or unsupported expert testimony without sufficient facts to back it up gets to the jury. The judges are supposed to exclude all that.
ありがとうございました。ですね、今一つ目の質問だったんですけれども、このテーマに使える時間がもうなくなってしまいましたので、ですね、UPC やフェデラルサーキットでのですね、オーラルアーギュメントのようにインタビューンしたかったんですけれども、まず最初の質問ということでインタビューンせずにですね、聞きました。で、ちょっと一つだけですね、ぜひ聞きたいことがありますので、質問したいと思います。ですね、アメリカでは基本的には当事者主義ということで、当事者が当事者が裁判官を説得するのが仕事であって、それは反対尋問などを通じて、裁判官あるいは陪審を、いかに説得できるかっていうところが、やはり重要視されていると。他方で、日本や韓国それから UPC は中に、技術系の人を入れているわけですけれども、当事者から見てやはり不安になるのはその技術系の中の人っていうのが、公平で正しいのかどうかっていうところの透明性のところですね。そこについてどう配慮するかっていう点ですけれども、これ韓国のハン委員長から、お考えをお聞かせ願えますでしょうか。
네, 매우 좋은 질문을 주셨습니다. 그 답변 전에 그 모두의 시로야마 변호사님께서 내부 기술 전문가의 보고서나 내용들이 공개되는지를 좀 궁금해 하셨는데, 그걸 먼저 말씀드리고 나서 답변을 드리겠습니다. 내부 기술 전문가에 이루어지는 그 보고서 작성 또 내부 기술 설명은 법관이 해당 사건의 재판 준비를 위해서 기술을 파악하는 과정입니다. 이런 연유로 내부 기술 전문가 작성의 보고서나 기술 설명은 당사자나 일반인에게 공개되지 않습니다. 이는 각국이 운영하고 있는 재판연구원 제도와 유사한 제도로 이해하시면 되겠습니다. 네. 이어서 질문에 대한 답변을 하겠습니다. 당사자들은 내부 기술 전문가의 객관성과 투명성에 대하여 우려를 가질 수도 있습니다. 그러나 법관은 내부 기술 전문가의 보고서를 검토하고 그들의 기술 설명을 듣기는 하지만 내부 기술 전문가의 의견이나 기술 설명에만 의존하지는 않습니다. 변론을 열기 전에 그들과 충분한 토론을 거친 다음 확인하거나 심리가 필요한 쟁점 사항을 구체적으로 정리하여 당사자에게 성명 준비 명령을 내려 해당 쟁점에 관한 쌍방의 추가 공방을 거치도록 함으로써 내부 기술 전문가 의견에 대한 객관성과 투명성을 높이고 있습니다. 또한 앞서 말씀드렸듯이 아까 질문을 뺐으니까 얘기를 안 했네요. 네. 법관은 변론길에서 이루어지는 당사자의 기술 설명, 또 쌍방의 공방, 증거조사, 전문심리위원 활용, 전문가 정의신문 등 여러 단계의 과정을 거침으로써 내부 기술 전문가의 의견은 적절하게 탄핵되고 검증되는 절차가 이루어질 수 있습니다. 법관은 기술 이해를 위하여 내부 전문가를 활용하지만 내부 기술 전문가는 어디까지나 법관의 기술적 이해를 돕기 위한 보조자일 뿐입니다. 재판의 주체는 언제나 법관입니다. 법관은 재판 과정에서 자신의 기술적 이해가 정확한지 끊임없이 확인해 나감으로써 내부 기술 전문가 의견의 객관성과 투명성을 확보해 나가고 있습니다. 더구나 대한민국은 IP 전문 재판부와 IP 전문 법원을 운용하고 있습니다. 이공계 출신의 법관들도 다수 배치되어 있습니다. 또한 특허법원에는 장기간 근무하는 법관도 많아 기술적 쟁점을 심리하고 판단하는 능력이 우수합니다. 법관이 내부 기술 전문가의 의견에 휘둘리는 일은 거의 찾아볼 수 없습니다. 이상으로 답변을 마치겠습니다. 감사합니다.
はい、ありがとうございます。じゃあちょっと時間の関係もありますので、今までの海外ゲストのご発言を受けて日本のパネリストにちょっとお聞きしたいと思います。まず利用者の立場からですね、藤川弁護士の方からコメントがありましたらお願いします。
はい。まずパネリストとして発言する前に、一言申し上げます。我が国の知的財産高等裁判所が、設立20周年を迎えられたことについて心よりお喜び申し上げます。この20年間、あるいはそれ以前から長期にわたって、より良い知的財産訴訟プラクティスを目指してご努力をされてきた裁判所の皆様に敬意を表したいと思います。先ほど大きく分けて特許権をめぐる紛争の専門裁判所の設置の在り方と専門裁判所における技術的知見の収集の在り方について各国地域の制度の紹介がありました。でこれらのうち専門裁判所における技術的知見の収集の在り方についてコメントしたいと思います。本日の報告では各国いずれも裁判所が透明性客観性に配慮しながら多層的かつ多角的に技術的知見を収集するということによって適切な判断がされるように制度的な手当がされていてかつ運用もされているということがよく分かりました。レジュメ等を拝見しますと各国の総意の中で例えば技術専門家の扱いに関して証人尋問の実施がされるかどうかということで比較的大きな違いがあるという様子が伺いました。これらの相違というのはどれが望ましいのかということではなくて特許紛争の適切な解決という対極的な観点から各国のさまざまな歴史的な経緯を経て蓄積されてきたプラクティスとして尊重されるべきだというふうに考えております。その一方でこれまでのプラクティスを所有のものということにするのではなくて弁護士としてもより工夫をしていきたいなというふうに考えた次第です。で最後に申し上げますと特許訴訟に出てくる技術的事項について裁判所に適切に判断をしていただいて適切な結論を導いていただくためにはまず代理人自身がその技術を理解してこれに基づいて分かりやすい適切な主張立証を行うということが必要になります。でそのような当事者による充実した主張立証活動と先に述べた裁判所内での専門的知見の充実に向けた体制と運用が組み合わさって最終的に適切な結論が導かれるということになると思います。本日議論としてはいろいろと予定通りにいかなかったというところもあるかと思いますけど、事前のレジュメであるとかですね、あるいは本日の話も勉強をさせていただきまして各国の制度とか運用を比較することでより充実した主張立証活動ができるというさまざまなヒントをいただいたと思います。ありがとうございました。
では知財高裁の中平判事お願いします。
これまでの説明にありましたように、日本では裁判所調査官と専門委員によって技術的な理解を裁判官が理解を得るということをしております。それで調査官の役目としては中立的な立場で技術を裁判官に説明し、裁判官が当事者双方の主張を的確に理解できるように補佐するという役目を果たしております。専門委員の説明でございますけれども、実際はこれは技術説明会を開いて、そこで当事者双方が自らの主張や証拠についてパワーポイントを使って説明をする。両方の当事者がパワーポイントを使って説明をする。その上でそれを踏まえて専門委員が当事者の前で裁判官 に説明をするというような形で行われております。それで、専門委員から当事者双方について質問がされることがございまして、それについて両当事者が答えると。それによって、専門委員の説明に対する、当事者からの、追加説明ですね。それも行われるということがございますので、その専門委員の説明がですね、当事者双方の面前で行われる。それから、質疑応答が当事者と専門員の間で質疑応答が行われることもあると。そういうことを通じて専門員の説明が適切に行われるという効果が確保されているのではないかというふうに思われます。本日海外ゲストから伺った情報に基づいて、難しい事案であっても適切なですね、判断をすることができるように、これからも審理の運営を改善していきたいと思っております。以上でございます。
はい、ありがとうございました。じゃあ、お時間もありますので、次の話題ですけれども、判断の社会的インパクトをいかに適切なものにするかについて考えていきたいと思います。裁判所の判断はもちろん当事者間の紛争を解決するものなんですけれども、特に知財事件では裁判所の判断が事実上企業の行動に影響を与える場合があります。このように判断に波及的な効果がありそうな場合により裁判所が広い視点に立つことを助ける制度として、今回はアミカスキュリエの制度ですね。日本では第三者意見募集制度として特許侵害訴訟に導入されておりますが、これを取り上げたいと思います。では城山弁護士から調査の結果を報告していただきます。
はい、日弁連知的財産センター、ここはですね、日野英一郎委員が、調査してくれた内容を報告したいと思います。日本については、これはご承知の通り、今ご紹介もありましたけれども、2022年4月より第三者意見募集制度が施行されております。でそれ以前はですね、裁判所の訴訟指揮の下で、2014年にアップル・サムスン事件において、第三者意見が募集されるということがありました。で、2022年4月の施行以後はですね、その制度の下で2件の事件において第三者意見が提出されて募集されています。1件が国境をまたぐネットワークシステムに関する事件、2件目が医療関連行為の特許的確正が問題となった事件でありました。続いてアメリカです。でアメリカでですね、多くの事件でアミカスキュリエが提出されていると理解しております。で特に CFC のですね、さらには特にアンバンク大合議の事件においては多くのその第三者からのブリーフが提出されているようです。で特にアメリカの特徴としては、そのパブリックセクター、公的な機関ですね、司法省とかそういう機関が意見を提出することも多いようであります。で最近ちょっと聞いたネット上で私が見たニュースですけれども、 NP が原告になっている連邦地裁の特許事件で司法省がですね、差し止めを認めるべきだと、 NP が原告だけれども差し止めを認めるべきだという方向の意見書を出したというようなニュースを目にしたこともございました。続いて UPC です。UPC ではそのような第三者の意見を募集する手続き、制度というものは用意されなかったと理解しております。でこの辺はゴラミンスキー長官、20年間制度設計に関わってこられたということなので、何らかその辺の背景とか意図とかご説明いただけるとありがたいなと思っています。ただ、ですね、SEP 標準品質特許に関するパナソニック対オッポの事件の判決で、別の事件で提出された欧州委員会の競争当局の意見が参照されていると、それについて両当事者議論して裁判所が判決によって言及しているというものがあったということを聞いております。続いて韓国です。韓国は、憲法裁判所においては、そのような第三者意見の提出というものが制度として存在するようですが、一般の民事事件、特許の侵害事件においてはそのような制度はないということのようです。ただ、 無効審判では2023年の法改正で、参考人の意見提出が、の制度が設けられたと聞いて、おります。はい、以上です。
ありがとうございました。じゃあ、ちょっとですね、時間の都合がありますので、イエスのクエスチョンで、特にアメリカの、アミカスブリーフ制度について、せっかくの機会ですから、チェンハンジについて、チェンハンジに対してですね、お聞きしていきたいと思うんですけれども、まず、アミカスでは、事実の問題、それから法律の問題、両方について、意見を聞くという認識で良いのでしょうか。
Thank you. Yes, the United States has a long history of an amicus brief system, which is literally defined as friend of the court, where not only are the parties having their opportunity to be heard, but we will consider other briefing from other parties that have an interest in the case. And it's really not so much as the facts of a given case, but really more broader implications of choosing one articulation of the law versus a different articulation of the law, and what the consequences would be of different understandings of the law. And that's the most common form of an amicus brief. Some examples of a very helpful amicus brief will be when we are dealing with a difficult novel legal issue, and we know that the consequences will be great, and the parties really, they just have their own narrow interests at stake in any given litigation. They just want to win their case, and sometimes they're not really being thoughtful enough about the broader implications in the law of if we decide the case in their favor. And so that's where I think good amicus briefing can really help. Sometimes amicus briefing is very useful to let the court know, do not write your decision broadly. Please write a narrow decision, because if you write a decision that's written broadly that invalidates this claim, then you're going to also impact all these other industries. So if you just write narrowly in just deciding the case on this one patent claim, then you will give us and other parties a chance down the road to fight out what the implications are of your decision here for other industries, other technological industries. So that is useful because as I mentioned yesterday, it's important to be careful about not writing opinions too broadly that might have unintended consequences that the court wasn't really anticipating. Another, I think, very useful kind of amicus brief is one that is provided by academics, by law professors or legal historians, that can give and offer the court an historical accounting of the evolution of a statute or the evolution of a legal doctrine, like doctrine of equivalence, and will discuss in some detail Supreme Court cases from the 1800s. And the parties aren't interested in going that far back, but it can be useful to get that kind of understanding because that still is applicable governing precedent that the Federal Circuit has to consider, at least until the Supreme Court itself rejects those Supreme Court opinions from the 1800s. There are times where one party is not being represented well by a lawyer, and the lawyering is poor, and then therefore you're not really getting both sides adequately of a given case. And an amicus brief can come in and actually be very helpful that supports the side with poor legal representation. And in other instances, for example, the Federal Circuit had a recent N-Bank case dealing with President Trump's executive order, which raised tariffs on basically all imported goods from the world. And there was a tremendous number of amicus briefs filed. And what I found helpful was there were so many different issues to be debated in that case that some of the amicus briefs, they just focused their brief on one of those issues. And the parties, they had to distribute their limited briefing across 9 different issues. And so therefore, some of the amicus briefs actually had better developed discussions about those legal issues because they were just focused on a single issue. Those are examples of why amicus briefing can be helpful. It's to get a better understanding of what the law should be, and also to get a better understanding of what the consequences are, consequences to consumers, consequences to various different industries, and then also sometimes even analogies to what the laws are in other countries, and how maybe there's an opportunity to try to align United States law with other countries' law.
ありがとうございました。もう少しだけチェン判事にお聞きしたいんですけれども、これはもうイエス・ノーでお答えいただけると思うんですけれども、アミカスブリーフ提出された内容っていうのはパブリック一般の市民は見ることができるんでしょうか？
Yes, it's all filings are part of the public record. Unless, of course, there's some business proprietary information that's in the brief, and then there is an opportunity to keep that confidential, of course.
ありがとうございました。で、事件によっては、もう一つ追加ですが、事件によってはですね、ものすごい量のアミカスブリーフが提出されることもあるかと思うんですが、判事は何かフィルタリングされたものを見るのか、それとも全てやはりちゃんと目を通すとかっていう、ちょっと答えにくいかもしれませんが、どういったふうにやっておられるのかお聞きしたいと思います。
The official answer is I read everything. But some briefs get more attention than others. That is probably true. So a lot of amicus briefs, particularly from various different organizations that are consortiums of companies or bar associations, the briefing, it doesn't get too deep, and so it doesn't offer too much, because they're trying to just give a broad generic position that represents a large number of companies or lawyers. And so they actually are in some ways restricted in how much they can say. And so those kind of briefs tend to get less attention because I'm not really getting a chance to get anything new or interesting that helps me think more deeply about a case.
ちょっともう一つですけども、例えばですね、団体の立場上両論を併記せざるを得ないっていうようなブリーフが来た場合に、それはなお判事の判断に役に立つのでしょうか？
Okay. We do not get briefs like that. And that's why sometimes the briefing we do get from maybe a bar association or a large organization will be watered down and therefore doesn't say too much. It would look a little crazy to the court, I think, if a brief looked schizophrenic and said, well, the most of us think this claim is valid, but a large part of our organization also, to the contrary, thinks the claim is invalid. So we wouldn't really, that wouldn't be very helpful, I don't think.
ありがとうございました。では少しアミカスの話から離れてですね、 判断のインパクトっていうのをどう考えるかっていう点でグラビンスキー長官にお伺いしたいと思いますけれども、 UPC の判断はまさにヨーロッパ全域に、全域ではありませんが加盟国の多くに影響を与えるということで、テクニカリークオリファイドジャッジを入れるなどして多様性を保ってインパクトを考えておられると思いますが、判断のインパクトを考える際に重視されている点を端的にお答えいただけると助かります。
Allow me just to develop a bit on the landscape in patent litigation in Europe. We have essentially three flows or three prongs in Europe. The one is represented by Mr. Gschwind in the previous panel, the European Patent Office, and on top as a judicial competent for judicial review, the boards of appeal, and they decide on all issues of validity. And they are independent. They decide as they like on the basis of the European Patent Convention. And then we have the national courts that are existent and will be existent also in the future because they are not replaced by the UPC, at least not with regard to the national patents. But they also decide on the basis of the European Patent Convention, at least when it is about validity. But when it's about Article 69, for example, they decide on the interpretation of patent law. That's the basis for claim construction for European patent, and exactly the same wording applies also to national patents. And then we have the UPC now, the new player, and they also decide on the validity and also based on the European Patent Convention. And there is no Supreme Court like in the US or in Japan who has a binding final say on how to interpret the European Patent Convention. And how does it work in Europe? Do the one go to the left, the other go to the right, and give different interpretations? And in practice, at least that is my observation, all the three try to align to the extent possible, to give a harmonized interpretation of the law to the extent possible. And how does it work when there is no binding court? Well, it works with persuasive authority. So there's a decision out decided by the UPC, by the boards of appeal, and for sure it will be submitted and get known to the for example, to a national court when the same question arises. And then it is up to the court to decide whether to follow or have the same interpretation or have a different view on this. And my understanding is that in case of doubt, you would prefer the harmonized way. Only if you strongly believe the other court got it wrong, then you would take a different view on this. And there's a very interesting example for this kind of alignment. So the national courts and the UPC, as they have to decide patent infringement and validity at the same time, they cannot give a different cannot interpret the patent claim differently when it is about infringement or when it is about validity. And there it is laid down in Article 69 in the protocol that when you do claim interpretation, you always have to look into the description and the drawings of the patent specification. And at the Board of Appeal, with all due respect, there were different views for some time. And now, very recently, one technical board filed a request to the enlarged Board of Appeal, which has a final say when it comes to interpretation of the European Patent Convention within the EPO, and asked the question, well, do we only have to look into the description and the drawings when there is a case of doubt, it is not clear in the claim, or do we always have to look there, like the courts do? And the result is, even though they did not explicitly refer to Article 69, the result is, yes, you have always to look into the drawings and into the description when you interpret the patent claim. So that, I think, is a very good example how it works with the alignment and having the same harmonized approach as to the interpretation of the law. And it is also true that courts tend to cite each other when it is about the same provision. For example, the German courts, when they become aware that English courts already issued a decision on how to interpret a certain provision of the European Patent Convention, and they cite the English courts. So the German courts cite the English court, and the English courts cite the German courts, and they cite the boards of appeal, and they cite the Dutch courts. So that kind of dialogue between the courts is very important in Europe, and that makes sure that at the end of the day, you do not get, at least in most of the cases, a different approach or a different interpretation of the law in whatever prong you are at the moment. So I think that is maybe quite interesting, also on the background of this diverse picture of Europe, because we are not only one big state, but we are so many.
ありがとうございます。では、韓国でもですね、知的財産高等法院の判断の影響力大きいと思うんですけれども、当事者以外のものへ、の影響をですね、考慮するためにどういった点に留意しているか、またはアミカス規例に類似した、制度の導入の予定などについてですね、範囲長と具体的な経験ももしありましたらお聞かせいただければと思います。
네, 말씀드리겠습니다. 그 답변하기 전에 아까 시로야마 변호사님께서 한국 제도를 잘 설명해 주셨는데요. 그거 다 맞는 말씀이고 한 가지만 더 추가하고 답변 드리도록 하겠습니다. 대한민국은 2015년 1월에 대법원 규칙인 민사소송 규칙하고 형사소송 규칙을 개정해서 일반 민사소송 및 형사소송의 상고심 단계에서 미국의 그 아미쿠스 쿠리에 제도와 유사한 제도를 도입했습니다. 내용은 이제 소송 당사자가 아닌 국가기관과 지방자치단체가 공익과 관련된 사항에 관하여 대법원에 재판에 관한 의견서를 제출할 수 있습니다. 뿐만 아니라 대법원이 소송 관계를 분명하게 하기 위해서 공공단체 등 그 밖의 참고인에게 의견서를 제출하게 할 수 있도록 하는 그 참고인 의견서 제출 제도가 도입되어서 운영되고 있고, 그동안 여러 사건에서 관계기관과 단체 의견이 제출되어서 대법원 판결에 참작을 했습니다. 하지만 이건 의견이라서 아까 뭐 그 사회자께서 몇 가지 질문하셨지만은 다양한 단체에서 의견을 낼 수 있기 때문에 상이한 의견이 나오는 것은 너무나 자연스러울 것 같습니다. 그런데 문제는 뭐냐면은 그런 의견이 나왔을 때 물론 법원으로서는 판단이 어려울 수는 있습니다. 하지만 법원에서는 그러한 의견이 있음을 고려하고 나서 최종적인 판단을 할 수 있다는 점에서 그것이 상이한 다양한 의견이 나오더라도 특별한 문제는 없다는 말씀을 드리고 이어서 제 답변을 이어나가도록 하겠습니다. 그런데 이제 대법원에서는 이런 아미쿠스 쿠리아와 같은 그런 제도가 마련되어 있지만은 대법원이 아닌 하급심 단계에서는 이런 그 제도가 마련되어 있지 않습니다. 또 대한민국에서는 하급심에서 도입 여부에 관한 논의가 그다지 활발하지는 않습니다. 다만 저는 이 재판이 우리 사회의 건전한 법 감정을 담아내는 것이 온당하다고 생각합니다. 법관이 재판을 통하여 사회가 발전해 나갈 바람직한 방향을 제시하는 역할을 담당해야 된다고 생각합니다. 이를 위해서는 대법원이 아닌 하급심에서도 일본과 같은 제3자 의견 제출 제도를 도입할 필요가 있다는 것이 제 개인적인 생각입니다. 저는 평소에 재판을 하면서 사회적 파장이 큰 사건을 심리할 때는 비록 아미쿠스 쿠리에 제도가 없지만은 해당 분야의 전문가들을 감정 증인으로 채택해서 그들로부터 그들의 학식과 경험에 의해서 알게 된 사실을 심리하거나 또는 국가기관이나 공공단체에 대한 사실조회 등의 방법을 활용하기도 하였습니다. 구체적인 사건은 시간이 없기 때문에 생략을 하고 결론적으로 말씀드리겠습니다. 다만 이러한 전문가 증인 신문이나 사실조회는 사실관계를 확인하는 방식이라서 국가기관이나 공공단체의 의견을 직접 듣는 데는 다소 한계가 있습니다. 그렇지만 해당 쟁점에 관한 사실을 상세하게 심리함으로써 국가기관의 의견이나 국민들의 법 감정을 어느 정도 추론해 볼 수 있었습니다. 다른 한편 저는 구체적인 사건이 아니라 하더라도 평소에 교수님들이라든가 실무가들로 구성된 여러 학회 활동에도 꾸준히 참가하고 있습니다. 이런 활동을 통해서 자연스럽게 사회적 파급력이 있는 이슈에 관한 전문가들의 식견을 자주 듣습니다. 이를 통하여 전문가나 일반인의 법 감정을 추단해 볼 수도 있습니다. 다만 이것은 제가 담당하고 있는 구체적인 사건에 대하여 의견을 청취하는 것은 아니고 최근 논란이 되고 있는 이슈에 관한 학계나 또는 업계의 다양한 목소리를 청취하고 그 이슈를 공유하는 차원입니다. 감사합니다.
ありがとうございました。じゃあ、今までの議論を踏まえて日本のパネリストから、ご発言いただこうと思いますけれども、まず藤川弁護士からお願いします。
本日、お話をいただいた、各国の、判事からは共通して、当事者のみならず他の事業者への影響を与えうる事件において、各国の制度というのはさまざまでアミカス・キュリエを有する米国、そして、UPC、韓国では、アメリカのような制度ではないというところで、いろんな制度があるわけですけど、それぞれ裁判所の判断の社会的インパクトが適切なものになるように意識をしておられるということがよく分かりました。とりわけやはりアミカス・キュリエの制度を有する米国のチェン判事のご説明が大変印象的でありました。先ほどその第三者から出てきたアミカスブリーフについて国民が見ることができる。で裁判所も見るということでありますけど、日本ではそもそも訴訟記録はネットで公開はされておりませんし、利害関係人のみ閲覧ができるということにですね、限られているということですので、そこはですね、制度としてはだいぶ違うのかなというのが1点と、あと、特許法上のその制度としても、証拠として当事者が選んだものしか、この裁判では採用されないということですので、かなり違っているなというのが印象的であります。で、その我が国の特許法の制度の下で、今申し上げたようにその当事者が選択したものからしか証拠として提出されないということになりますと、当事者は自分に有利な証拠っていうのは当然、それを選択して提出をするわけですけど、そうではなくて不利なものは出さないということになりますので、有利なことと不利なこと両方が書いているものというのは、多くの代理人はその意見書は証拠として出さないという無難な選択をするのではないかというふうに推測をいたします。そうしますと、この裁判所にとって本来大変参考になるであろう意見書であっても、証拠として利用できないという点でもったいないということになりますので、 この点運用でですねなんとかならないのかなというような印象は個人的には持っております。法改正の前でありますけど、アップルとサムソンの事件の時には、この制度ができる前に裁判所と当事者が協議をして、第三者から出された意見書が全て証拠として提出されたというような運用があったというふうに伺っておりますので、そういったことも参考になるのかなというふうには思います。でそれとですね、もう一つチェン判事の話で印象的でしたのは、このアミカス・キュリエの制度が法律論として深掘りをしているものがあって、それが非常に参考になるものがあるという話であります。で我が国の第三者意見募集制度の立法趣旨としては、先端的な技術あるいはビジネスというのが非常に当事者以外の第三者に与える社会的なインパクトが大きい事件、あるいは外国法で参考になるというようなものについて広く意見を募集するという、それだけに限られたということではないんですけど、立法の過程ではそういったことが中心に議論されてきたのかなというふうには理解しております。で、法律論として深掘りをするということについて特に議論をされてきたわけではないというふうに理解はしてるんですけど、他方で別に法律上それを制限するというような理由もありませんので、今の話っていうのは大変示唆に富んでいるのではないかなというふうに思いました。ちなみにですね、日弁連の方でもこれまでこの2回第三者意見募集について意見書を提出したことがございます。1回目は制度ができる前の先ほど申し上げたアップルとサムソンの事件の際に提出をしましたのと、もう一つは今年ですね判決があった法教よそ生物事件についてのものであります。これらはいずれも日弁連のネットでホームページで公表をされておりますので、高知の情報であります。で日弁連がその意見書を出したのはですね、国民の司法参加という観点からこの制度が非常に有意義であるということで法制定の際から賛成をしてきたというような経緯もございまして提出をしたということであります。でその際はですねこれ日本の弁護士はすべて日弁連に加盟してますので、どちらか一方だけの意見を書くというわけにはいきませんので、両論併記にどうしてもならざるを得ないというところがございまして、それであってもですねなんとか法律論として深掘りをして参考にそれぞれしていただけるような内容に、今後どういう事件でこの制度が使われるかっていうのは分かりませんけどしていければ大変望ましいというふうに考えております。以上でございます。
はい、ありがとうございました。では、知財構成の菊池判事からお願いします。
はい、ありがとうございます。こちらのこの日本の第三者意見募集制度ですけれども、2021年の法改正で導入されたということで、ただその前にからですね、もうすでに実務的なアップルサムソンの先ほどから出ている事件で、実際にその意見募集をしたという事実もあったということが積み重なっているかと思います。で、今まで2回経験したということですけれども、おそらく肯定的に受け止められているのではないかというふうに思いますので、今後も運用等にはいろいろとしていければいいかなというふうに思っております。この第三者意見募集によってですね アメリカのそのアミカス・キュリエ制度と、同じということではないんですけれども、やはり当事者以外の第三者の意見を広く募ることができるということで、それで裁判所がその判断の影響ということをやはりよく考えることができるということが可能となっておりますので、非常に意義のある制度なのではないかというふうに思っております。当事者からの申し立てを要する、証拠収集というような位置づけなのかと思いますけれども、その中から当事者が訴訟にして実際に証拠として提出していくという制度ではありますけれども、先ほどもいろいろな悩みも出てくるのかとは思いますけれども、やはり判断の影響が強いと考えられる事件の中では適切に活用されていくことが望まれると思います。で特にですね、やはり知財事件担当しておりますと、非常に社会的に影響を及ぼすのではないかということをいろいろと留意しないといけないということがやっぱり年々考えるようになってきているのではないかと思われます。裁判官は、もちろん第三者意見募集制度でですね、その広くということでもちろんいろいろなご意見等も検討しながらということではございますが、それだけではなくてですね、やはり広くいろいろなところに視野を広げてということで常に幅広く学びながらまたこのようなですね国際会議等も含めてですね多くの方々と交流を深めて常により広い視野に立って判断できるようにということで自己検査をしていく必要があるのではないかと思いました。以上です。
はい、ありがとうございました。今日はですねこの2つのキーチャレンジを使って、話をしていきました。時間が限られていますので、なかなか深い話がまでできなかったかもしれませんけれども、皆さんが、自分たちの中でインスピレーション、持っていただければいいかなと思います。それでですね、もうちょっと先の話をしたいと思います。未来高名な判事の皆様には今から10年後を想像していただいて、一体知財司法ってどうなってるんだろうかっていうのをちょっと想像していただいて、どのような景色が見えているかですね、ちょっと教えていただけるかなと思います。どうでしょうか、한委員長。
네, 말씀드리겠습니다. 저는 법관이고 미래학자가 아닙니다. 제가 어찌 감히 10년 후에 우리 미래를 전망할 수 있겠습니까? 다만 질문을 주셨으니까 제 좁은 소견을 말씀드리겠습니다. 저는 AI가 급속도로 발전하는 미래 사회에서는 AI에 의한 판단과 인간 판사에 의한 IP 사법작용이 서로 경쟁하는 사회가 올 수 있을 것이라고 조심스럽게 추측해 봅니다. 앞으로는 당사자들이 AI를 이용하여 도출되는 결론을 근거로 법정에서 변론하거나 이를 이유로 법원의 판결에 불복하는 일이 많아질 수 있을 거라고 생각합니다. 오픈 AI와 같이 많은 데이터를 가진 AI 운영 업체보다 훨씬 적은 정보를 갖고 있을 뿐이고 유용한 판별 도구를 갖지 못한 우리 IP 법원이라면은 그 판결의 정확성이나 합리성에 관하여 신뢰성을 얻지 못할 수 있습니다. 미래 사회는 인공지능의 발전에 따라 인간 판사에 대한 엄청난 도전의 시대가 올 것이라고 생각합니다. 감사합니다.
ありがとうございます。グラビンスキー長官、お願いします。
If you allow me myself to limit to patent cases or justice with regard to patent litigation, and I share the approach of Chief Judge Han regarding the importance of AI. In two angles. The first one is that what role does it play in the life of a judge? I'm not afraid that judges will be replaced by AI in 10 years' time. I think we are not there, but I think it is a very sophisticated tool. And it may help, for example, to do research about relevant cases for deciding your case. It is already used by lawyers that I know, and I'm sure this tool will get much more sophisticated in 10 years' time, for sure. And why not also have the court make use of it? Like nowadays, the judges go to the library and have a commentary and find out about more case law. And in the future, it will not only be the commentary, maybe there will be no commentaries any longer, it will be just only AI that gives you a broader perspective on how to decide certain legal issues. So as a tool, I accept AI, I think it's very useful, but when it then comes to the fact-finding, establishment of facts, so is it true or is it not true, a relevant fact? And then when it comes to decision making, I think AI should stay out of the room. That is, otherwise it is not under control of, and AI also has its downsides. Well, we know now hallucinations that maybe not to that extent we see it nowadays, maybe better in the future, but who can exclude? It is, after all, it's a black box. And you're not sure what is the basis, what AI is using. Just ask one question to one AI nowadays, and then ask the same question to another AI, and you will be surprised. You get different views from time to time. So don't rely on AI. Always control AI. That, I think, is also very important. And then, of course, the other perspective is that of a patent judge. To what extent does AI matter in the patent field? We have seen the Davos case, and in the Davos case we have judgments, decisions from all over the world, and all the courts at the end agreed that AI cannot be an inventor. So it's a human being, and at the moment, to my understanding, it's always a human being who initiates the process. There is no AI that says, now this morning I feel like making an invention. This kind of AI, fortunately, does not exist at the moment. And so there is always a human part in AI, in making inventions. And AI is a tool in that regard. And so that is also important. I'm waiting for a case where AI plays a role when it comes to the question like novelty or in particular obviousness. But I guess it will be very difficult to have facts on this, because AI again is a black box, and then to prove that 10 years ago there was AI available in the hands of the person skilled in the art, and because of that it was obvious. I'm waiting for this kind of argumentation coming to my court, and I can decide on this. And also when it comes to sufficiency, so enablement, there it will be also interesting to see to what extent AI then can be part of the patent specification, because as you know, there should always be a way how to implement an invention, and to what extent does AI play a role there? Again, the black box aspect will come up. So there's a lot of things very interesting for the future to be decided by a patent judge. And then one more thing, so that has nothing to do with AI, is SAP and FRIEND. I guess it will still be on the table also in 10 years' time, and will be another very important aspect of patent law. Thank you.
はい、ありがとうございました。では前半時引き続きお願いします。
First, I'll just quickly say, I think because the patent system has become so important and even central to economies, including the United States economy, we're going to probably continue to see political involvement in that agency. And I used to work at the USPTO for 15 years before I became a judge in 2013. And for the most part, it just was about applying the law and trying to issue valid patents and valid trademark registrations. And so it was a very, very technical-based agency, and it wasn't worried about larger policy implications. But now I think going forward, there's just been this growing politicization of the agency. I'm not saying that you can expect new administrations to just ignore the law, but what I am seeing more than before is that new administrations are always moving policy levers, and the USPTO is starting to become one of those policy levers now, that in a way that it wasn't really considered to be in prior decades. The entire question of artificial intelligence, it really is probably going to be, I think, the most prominent new thing that we all have to wrestle with, whether it's litigation or it's IP litigation in particular. Right now, inside the United States, there are a lot of copyright infringement cases going on where we're fighting over the data inputs and whether it was fair use for all these different generative AIs to vacuum up data from around the web that's copyrighted material. So that is something that has to be sorted out. Then there's also the question of to what extent are artificial intelligence algorithms eligible for the patent system? That is going to be a difficult issue. Beyond the inventorship questions you just heard from President Grabinski, what if a person, an engineer at a car company with access to some powerful generative AI algorithm says to the AI, please design an electric battery configuration so that a car can go 5,000 kilometers without a recharge. And then 1 week later, the AI says, here you go, here's the design, here's the battery chemistry, here's the configuration of batteries. Who's the inventor? Right. We're going to have to battle questions like this. We're also going to have to think about enablement, as you heard. We're going to have to think about, do we have to redefine what is a person of ordinary skill in the art? What if AI stumbles upon infringing other people's patents? Who's liable for that? Can AI be liable for patent infringement? There is this very interesting question of using AI for legal research within the judiciary. It's right now a tricky question because of the dangers of reliability. And so judges and law clerks and other staff, we can see the value and merits of the efficiencies gained and maybe better, more relevant research that can be accessed through AI. But everything has to be verified because it turns out AI can invent its own legal authorities. And so there's an incredible amount of danger there, and there's ethical questions behind, therefore, leaning on AI for decision-making. I do think judges are still, of course, always going to be the decision-maker. It didn't occur to me until I heard Chief Judge Han say it that we can expect in the future maybe outsiders submitting all the briefing and the record of a case and then having the AI propose what the correct decision is and then us courts will be constantly second-guessed by AI saying that the court got the decision wrong. But in some ways, I already live that life now, because when in the United States we have these blogs on the internet where patent lawyers are always telling me I got my decision wrong. So, it seems like this is just another source of critics for me. But I think we don't know what's inside these black boxes, as you heard. And so that's why AI-generated evidence is also something that we're going to have to wrestle with, whether it's IP litigation or any kind of general litigation where a lawyer wants to analyze a huge data set and then gain interesting analysis and inferences by plugging that all into AI. And then we have to ask ourselves, is that something that's really reliable that can be entered into the record and considered? If it truly is a black box, and we don't know if there's potential biases, we don't know what kind of training data it was. And so I sense that district court judges are going to be the first ones that have to wrestle with all this, and I suspect they'll want to know quite a bit about the background of any particular AI that's being relied upon to understand whether or not it really is reliable or not to use as potential evidence. So the questions just go on and on like this. So I would expect AI. And then finally, I did hear Judge Grabinski mention this. We're going to continue to be even more and more interdependent as in a global economy. And I think courts, therefore, are going to be issuing decisions that impact not only their jurisdiction, but other jurisdictions as well. And so all of our courts, IP High Court, Federal Circuit, UPC, need to think about the extraterritorial effect our decisions have and to what extent that is something appropriate or something not appropriate. That's something we're going to have to wrestle with. With SEP France, it's almost inevitable. I mean, we can be aware of the extraterritorial effect, but it's hard to know how we can actually control that. So those are my three: extraterritorial effect in an interdependent global economy, AI, and then a little more politics at the USPTO.
はい、ありがとうございました。では JCIP の知財高裁20周年記念大会もいよいよ終わりの時間と、なってまいりました。今日は、2つのチャレンジとそれから未来について、一緒に考えてきましたけど、最後にザ・ゴールデンルールということで裁判官の、スピリッツといいますか魂についてちょっと聞いていきたいと思います。知財司法はイノベーションを支える、ための、インフラストラクチャーのようなものですけれども、時代は大きく変わっていって環境も大きく変わっていく中で、私たちが公正な最後の砦としてイノベーションを支え続けるため、裁判官として、最も重要な原則があるとしたら、それをどのようにお考えになるかっていうのを一言で、一言短いフレーズで教えていただければと思います。ちょっとフライトの時間の都合があるので、グラビンスキー長官からお願いしたいと思います。
I have to admit, I already mentioned it. For me, I think the right to be heard of the parties is a very fundamental principle. And before a judge takes a decision, the judge must be aware of the arguments and the facts presented by the parties. I think that's a very important principle to me.
ありがとうございます。では、前半時。
I'm not sure what to say. I would like to say something like, us judges have to approach our work like the whole world is watching. Okay, and what I'm the point I'm trying to get across is it's serious work, and we have to be fully committed, and we're not allowed to get tired. Even when we're tired, we're not allowed to get tired. We have to be stubborn about the way we approach our work and have a commitment to excellence. I mean, in the end, we might not always be excellent, but at least we can do our best to try. And that's all that anybody could actually ask of anyone, is to do their best. But whether it's the difficulty of the technology or just the complexity of the overall litigation or all the different dynamics, we have to ensure the fairness of the process. Without good process, you can't have good outcomes. I very, very sincerely believe that. And so we need to ensure all parties have that full opportunity to be heard, and to protect the record from things like questionable evidence and things like this. But I'll just say that, like the whole world, do your work like the whole world's watching.
ありがとうございました。では最後に、韓国のハン議長お願いします。
これはとても難しい問題です。제가 감히 말씀드리자면은 저는 IP 미래 사법의 핵심적인 원칙을 조화, 하모니제이션이라고 말하고 싶습니다. 부연하면 지속적인 혁신이 일어나기 위해서는 권리자의 이익과 경쟁자 또는 공공의 이익이 함께 보호되어야 합니다. 과도한 권리 보호는 후속 혁신을 저해하고 과소한 보호는 혁신의 동기를 약화시킵니다. 아울러 기업이 법적 위험을 예측할 수 있는 재판을 해야 합니다. 나아가 국경을 넘어 존재하는 IP 분쟁에 대한 각국의 IP 재판은 전문성과 합리성을 갖추어야 합니다. 각국의 IP 법원이 교류와 협력을 확대하면서 함께 서로 배우고 나누고 나아가면 세계 각국의 IP 사법은 조화를 이루면서 계속 발전해 나갈 수 있으리라 믿습니다. 감사합니다.
ありがとうございました。裁判官の皆さんのゴールデンルール、皆様の、心に刺さったということを信じて裁判所パートを終わりたいと思います。登壇者の皆さん、聴衆の皆さん、通訳者の皆さん、ウェブでご覧いただいた皆さん、どうもありがとうございました。
以上でパネルディスカッション激動する時代とこれからの知財司法を終了いたします。ご登壇の皆様ありがとうございました。